Mention not in the list.
Why is to be mentioned? Why do you want the matter to be listed as to be mentioned? So it will be for hearing, not to be mentioned. Very well, listed for hearing. But there are already matters in the list. It will be tagged on serially.
That matter which I had mentioned yesterday, passport from Calcutta relating to the demolition of the building.
Yes.
The only problem is that the copy of the supplementary which has been filed by the other side has been given. That copy has been given only today morning.
What I would say.
Where is the supplementary? Is it there on record?
No,
All right. And what was the requirement of filing the supplementary?
the second statutory appeal, as I remember.
Yes.
That Calcutta, very of the court was filed, copy of the second appeal statutory appeal pending before the left in Governor. Client had rushed in and in a hurry.
That was not there.
That was not there. And the pending building application for consideration is not yet rejected with the authorities. All these documents are there. But what I would say, this basically originates by way of the family dispute between two of the parties.
That is the truth.
There is also a possibility that this building plan can be sanctioned because there was a query and it was not refused also. Why not make grant and interim stay for a limited period and we come back with certain proposals so that the settlement can also be arrived and the municipal can also take instructions on this pending building application.
Yes, and in pre granting it, there will be a difficulty.
Limited time.
What I'm suggesting is the authorities can be requested by this honorable court that suggests the authorities not to take any action till Wednesday. Possibly by Wednesday there is a chance of settlement.
Settlement between two of y'all or the council will also be there?
No, once it is settled between these people, there is a possibility that the council also will get it settled because this is a case relating to the sanction of building plan where they say that building plan is already pending. When it is pending with the authorities, then of course, they can look into it and get it sanctioned. There is no difficulty.
Only a very small query which can be addressed, the building plan can be sanctioned by. So
Let me hear the council once.
So far as the building plan is concerned, my lord, when they have filed, it has been already rejected.
Rejected? Show me the rejection. If that be so, then the entire submission of the parties that the plan is pending consideration fails.
No.
Show me the rejection and was this rejection communicated to the parties?
Any 55 of the supplementary application.
Let me give us a copy.
Here, before my page 55, this address the mechanism of what is being worked out in code level. Submit the building plan to the municipal authorities. The municipal authorities, they will assess it and forward it to the town and country planning department of the administration. They will examine it in terms of the town and country planning regulation bylaw. And if there are any deficiencies, they will point it out back to the municipal authorities and to the applicant for addressing those issues. Once the communication is received, I will address those issues that resubmitted. Madam, may kindly come. This is a letter very interesting. 10th June 2020.
Yes.
It's a show cause notice which says that applicants should be fully responsive for the other residents of Tribunal have submitted a proposal for triple-story residential building of a survey number so and so Chandigarh village mixing an area of Toronto through the authorized officer secretary PBMC. The proposal was discussed in the meeting held under the chairmanship of PBDA on Spring 2020. As the said plot is approachable only by 1.7 meter wide path, and it would be difficult for movement of vehicle for the firefighting and other services to be plotted. During emergency, it was therefore decided in the meeting to refuse the permission by allowing development of residential building on the above plot. You are hereby given an opportunity to show cause in 15 days from the date of receipt of the letter as to why the permission should not be refused. This letter was never communicated to me, my lord.
Where from did you get it?
After the demolition order was passed, I went to the authorities and when they opened the file, I could gather it from there. I have stated so in my supplementary affidavit. Let them show whether this application was ever communicated to me.
All right. This is the only document against you.
This is the only.
Very well. Counsel, what is your submission?
The refusal was on 26 July 2020 because the town.
July.
Without taking into consideration.
1 minute.
2020, 6 July 2020, it was informed to the,
Show me the communication.
just holding it the.
Page 55, what has been read out is that 3-storied building cannot be sanctioned. So it can be 2-storied or changes can be done.
There was no issue with the building plan, number one. It was only limited to the issue of the approach. They said the approach is only 1.7
Yes.
times. Look, there's another issue to it legally. I have a constitutional right to own and possess and use my property. There has to be a law enforced if the rejection is to be on the count of approach. I'm not going that far, my lord. Even I can challenge what's put firstly. There is no provision under the law.
No, there is an opportunity to show cause,
Yes.
whether you,
I can take these issues before.
everything you can take all these issues. Show me the rejection order, please.
The town plan is issued that the plan cannot be granted because of the reason that the
Communicated
was
through
not
that.
communicated, the show cause was communicated and.
Show me the communication, please.
The receipt, not in your file, the receipt.
Yes, certainly the receipt of intimation.
Letter of 6th July, I have come to note, which was prepared but never communicated by a forwarding letter.
3 pages. First was,
3 pages.
first one is the letter, which is communicated.
Show me the receipt.
Last one, 3rd page. The June group register.
Biswajit Biswas and others, 6th of July. It was communicated through hand service,
June of the- was on June book.
Peon book. So it has, see, this is the signature. Biswajit Biswas and 4 others.
My client has got. I learned it.
Alleging that this was the appeal of the elected commission everything.
This ground was actually never taken, madam. This was handled by.
You know, so this matter has to be heard. That
Has
is the
to be
reason
heard,
why
yeah.
I'm saying, you know,
So,
if you
I am
raise it,
saying so.
they will not be
can-
taking
can-
such time. But no stay.
There's a possibility. The possibility of settlement, there's a possibility of the plan being sanctioned by.
If the council has refused it, then what will the settlement in between the private parties do?
So far, never communicated to me.
If there is a document to
Let me
show.
Take instructions, but let them show it to me, my lord. Let me take.
They
instructions.
prefer an appeal also challenging that
Please,
order.
Appeal is against which order?
Case demolition.
They also, or they have.
My lord,
preferred
the
an appeal.
demolition order was passed, my lord, without taking into consideration the show cause notice, where I had an opportunity to address to the issues and to get it rectified by.
No, you had an opportunity and if you did not avail the opportunity, then what can be done?
They said,
The signature is there.
let me take instruction from my client, my lord, whether it is his signature or not. Actually, I affirm a false affidavit to court, my lord. And I have suffered so much, I can. Other supplements and suffer for them. The provision for submission of a defensive plan. The provision for compounding the violations. Provided the violations are compoundable. Provisional refusal is contrary to the law. There is no.
The order of Justice Mantha, which is appearing at page 19 of your writ petition, mentions about an appeal carried from the order of the Secretary PBMC before the Deputy Commissioner.
At the first appeal. At the first appeal,
Against which order?
against the order of demolition.
That means everything went on step by step.
Was never communicated to me, madam. I have this, before the second appellate authority, I have this option of taking this issue before the second appellate authority and getting the matter remanded back for consideration, madam.
Show me the second appeal, which you have annexed in the supplementary, you say? And please show me the provision for second appeal. Because there is a direction for demolition and for filing a report, compliance report. So, and the division bench has also not interfered.
And bench pilot has not interfered, pilot, not neither the refusal also.
Unable to produce a second appeal that he seeks. Show me the second appeal.
Supplementary affidavit, pilot. Page, that's pilot, page, page 9. Of supplementary affidavit, it was filed and served pilot on 4th of November. The order my lord of the legislative was on 13th of November, we were not served with the notice, my lord. The expedition was not served, we were not heard by us. At least the matter may, order needs to be, post my lord, and might be demanded back to the legislature. And opportunity be given to us to be heard by lord.
Your worship, how can you take note of this particular appeal, your worship, which has been filed after 2 years?
Which page did you say?
The appeal is of the.
Page? Page?
Page 9, my lord.
Page 9 of the supplementary.
Filed on 4th November against an order of 29 of
First is from.
3rd October 2024.
Where is the order dated 3rd October?
3rd October.
Page 57, I see.
Pilot, 57. This is the order of the first appellate authority.
It records that several opportunities of hearing were given to you.
That's before the first, definitely.
Whatever.
If it is there on record, I cannot.
Yes.
Mentioned now, that is not the ground in the appeal. In the second.
Appeal is dismissed with a direction to take necessary action. Where is the provision for second appeal, please show?
Pilot.
32.1.
Yeah, okay.
32.1.
1, 2.
1, 2. 32.12. Any person agree with the order of the appellate authority may prefer an appeal against the order of the administrator. But this is not the order of the administrator. This is the order of the appellate authority.
Is that order, it has to go before the administrator. Pilot.
3rd October order is passed by the deputy commissioner, which is the appellate authority. Where is the provision for second appeal?
32.12.
32.1.
Any person aggrieved by the order of the appellate authority may under certain may prefer an appeal against the order of the administrator.
Within 15 days. Now, can we
Aggrieved by
note
an
this
order of the
particular
appellate authority under may prefer an appeal against the administrator within 15 days. And your appeal at page 9. What is the date?
4th November.
Section 5 condemnation can always
Has
be.
not been filed.
Please, can always be filed. There are judgments, my lord, and my learned friend appeared, if you remember, many India. The division 1 judgment of this honorable court, where I had filed the appeal without the section 5, and section 5 was filed subsequently. The division bench decided over possibly by Justice Tenant and observed and held that it can be filed subsequently. These are curable defects.
Now, at this stage, whether this honorable court can take note of this appeal, when section 5 application has not even been filed.
The appeal has not been rejected by the applicant on account of the.
The administrator is the LG.
Why?
What is your submission?
There is an alternate remedy for the administration, you can go to the administration, ask for the state.
That is what I.
The appeal is pending, he says, before the administrator. That is different. Whether application is filed, not filed, allowed, not allowed comes later on. But there is a statutory provision for a second appeal before the administrator, and that is pending.
Station period of 13 November. I was not served. They did not appraise the order to court also that an appeal was pending. I mean, very unfortunate.
Is the administrator a party over here?
Yes.
Did you take this as a ground in the appeal that
Even
the
if I'm not taken it, I can say.
administrator is also not a party?
Still, as on dates, my lord, the administration is not a necessary party. Because he has not passed any orders at those two.
No, but then this is your primary ground that the appeal, second appeal is pending before the administrator. No, that is all right. What to do?
Handled by too many of them.
Please come.
Pass any beginning of the worship, let it be done on Wednesday, not today, because I have to make such submission. One main point I have to make submission, I don't.
Wednesday means tomorrow. And the council will not take any steps in the meantime. Single bench for what purpose? What is the further challenge? Compliance report. Then there is a direction already for compliance. This is what I was.
Because we have looked into from supplementary evidence has been given only today. Point is like, this particular person, he has said that he is the owner of the property on the basis of a guilty. And on the basis of that, he submitted the application for sanction plan. Because one has to be an owner of the property in order to get a plan sanction. Without that, it can't be done in any circumstances. Now, here what happened, that particular guilty has been set aside by the city. An appeal has been filed, but no stay is there.
Appeal was filed, initially there was.
Whatever. So, yes,
He is not even the owner of the property.
then there is no question of any construction being made.
Submitting the order. Things are, many things are there that are submitted.
Did you read my law?
I don't think that. Asking for good quality.
Work is still going.
Work is going on for demolition.
There will be, tenants or the collection.
Do you have your ownership document? A lot of issues.
Well, I told you that. If it was executed, basically, if the mutation was carried out, the records were corrected, I was declared, item was transferred upon. They challenged the defeat of the basis by way of a civil suit. The civil suit was declared in favor of Mrs. Max Time. We preferred an appeal before the first appeal court, before the London District Court. The London District Judge stayed the order and judgment of the trial court, and ultimately remanded the matter back to the London civil court for determining, deciding the issue afresh. Again, the order of remand was not came before the honorable court by virtue of second appeal. The honorable court observed there was no reason for remanding, and therefore instead of order of remand to the trial court, this honorable court remanded the
First appellate court.
But there is no stay.
It may not be.
No stay is there.
Technically,
No, it's not
I can
technical, because
definitely
we
give an
has been
application
set
for
aside
stay and.
by a competent court of law.
What you can do is different. You have not done it till now. This is to be seen.
And
No, it cannot be.
look, can you keep it on Friday, my lord? We'll come back, my lord.
That's what I am suggesting since the beginning.
All right. Heard submissions made on behalf of all the parties. Stop. The court has been apprised that the demolition proceeding is on. Stop. Paragraph. The private respondents may file an affidavit by Friday with a copy served upon the learned advocate representing the appellant. Stop. The Port Blair Municipal Council is directed to file a short report annexing documents to show that that all steps were taken in accordance with the relevant regulations for proceeding with the work of demolition. Stop. Such report shall be made ready by Friday and be served upon the learned advocates representing the respective parties. List the matter on 9th, next Monday. By Friday, you'll complete everything and come back, but no stay. The case for stay has not been made out.
Yeah, I think to find a document indicating that the photos was done.
Yes, they'll file everything. Yes,
Still fine.
it will be returned to you, this book also.
The original application is pending before the Central Administrative Tribunal. The cause for which the writ application has been taken is for a limited purpose. The tribunal at the first instance grants interim protection and the same tribunal vacates it. The order vacating the interim order is question here.
Can it not vacate it?
It can't be done. No, it can't be done. There has to be a change in circumstance. That's the first thing. And that must be a justifiable one. It's a matter of routine. It can't be done. Here it has been done as a matter of routine. The authority said that selection process is required to be done because there are no incumbents holding the post except one or two. That was the solitary reason why the tribunal said we are vacating the stay order. Not sure if the stay goes, not sure the entire original application becomes meaningless. It will be infectious. But I'll just show, I have to give the background of the matter. So unless I do not give the background, I may not be in a position to persuade this court that I have a good case, rather a prima facie case. So what has happened? I have filed the evidence of service. I've served it. I've filed it.
My lordship, my advocate is presently out of station, my lordship.
What is your name? He's the private respondent. Your advocate is not here.
He's reaching by today evening and keep the matter.
I'll take it up
But
tomorrow.
may I say one thing, Lord?
Yes.
I have some personal difficulties till
Tomorrow.
Wednesday to Friday. Can it be on Monday, Lord?
Very well, Monday.
I'm grateful. I'm grateful. I'm
By
grateful.
consent of the parties, let the matter appear in the list on 9th.
I'm just giving a spare copy to the private trustee. If she already received it, even then I'm giving a spare copy to her.
Inquire whether her advocate or she has received it or not.
I filed the service, Lord. Showing effective service. I gave her a spare. Still, charity I'm giving it to her.
तो हम इसको सब सब लाइन में
Number 3, WP 48 of 2024.
Here, Your Lordship, the challenge is to the order of the tribunal. Your Lordship, the person, may I submit a brief fact?
Is the other side there?
Yes, Mr. Shiva.
I think the copy today morning only.
Because I am praying for an interim relief. Let it be tomorrow, Your Lordship, no issues.
Very well, not today.
Item number 4, WP 89 of 2024. Item number
Please
Your
file
Lordship,
it.
yes, and for the petitioner, they were required to file the status report because for last 2 years, consumer court is not functioning.
I think this from the by speed post. I have a copy.
What has been dispatched?
Status
Status report. All right, you have a copy, soft copy?
I have.
Yes, what does it say? Why are the members not being appointed?
They have cleared all this.
Cleared everything. When will the courts be functional?
Administration will have to take steps. They have also.
If you are not, in the last quarter of this week, we have there is a good, but there are administrative, reasons for not appointing because High Court committee has to be consulted with led by Chief Justice. So those things are sort of pending before the Supreme with the order of.
Supreme Court?
Supreme, this matter is pending before the Supreme. But in the meantime, those have been clear
Yeah.
that the union has taken steps, they have assured that they are going to sit with the administration and will do the needful to take the bylaw.
How soon?
But that not, as soon as this meeting should be fixed with the Chief Justice of India.
No, but then you said it was pending before the Supreme Court. Now everything is clear.
But it's been clear, pending to before Supreme Court has cleared that this pendency will not lie between the appointment of this.
Right.
President.
And the selection committee by the Chief Justice is there. Is that functioning? The committee is there.
Committee is there, one meeting will be fixed and thereafter, the bylaw, the schedule of the ground meeting bylaw all will be fixed. That is in the report, Malad.
Give a copy to your learned friend. Is there any timeline mentioned within which it will be
So,
done?
timeline is not.
Till you can specify a time limit, how can your report be accepted? Tell me, is the state commission functional?
Yes, yes, state commission is functioning.
It's, is that going to learn?
Yes, state commission is functioning.
Function 1 day in a week.
पर ये कर रहा है अरे I heard एक मैटर था मेरा एक मैटर था वो जा रहे थे
If the state commission is functional, then the president of the state commission and the member can act as the members of the district commission forum and can take steps.
but then appeal
Appeal, there is a provision
There is
possibly
no
check
problem.
up the act I was.
because national commission appeal is there but
That
one
is
forum
right,
also will lose.
Yes, no, can understand that, but then I was checking up. That in case of unavailability of members,
तुमको मालूम है तुम बोलो ना फिर एक मैटर था ना वहाँ पे इसलिए state commission is functioning.
it is
Yes,
functional.
yes, Mr. Shivaram is there, one of the I think members.
Officiating president.
Yes, officiating president.
Officiating president.
Yes.
Check up the act once, right? I will want a timeline to be mentioned in the report.
So shall take this. Because these reports come from Delhi, it takes time.
No, this is from the union. You are there for the administration over here. So a report from the administration will also be required.
I should file this.
Next week, we are keeping it. When? Monday or
Monday.
Tuesday? Monday. The original report by the Union of India is yet to reach the learned advocate. Stop. A copy thereof has been filed before this court. Stop. The same is taken on record. Paragraph. The Please tell me in which portion it is mentioned that it is presently pending before the administration.
26 November को इससे पहले वाला सर और पहले आपका जो लेटर है Page number 10, Your Lordship, possibly this is the letter which has been issued by this Government of India. But that letter has been issued on 26th November 2024.
Yes.
And there they have said, paragraph 4. In view of the above, you are requested to expedite the process of appointments of the office of the presidents and members of the State Consumer Dispute Redressal Commission and District Consumer Dispute Redressal Commission.
A communication made by the Undersecretary to the Government of India, addressed to the Principal Secretary / Secretary, Civil Supplies, Food and Consumer Affairs Department, to all the state governments / UT administrations, dated 26 November 2024, is annexed. Wherefrom it appears that a request has been made to the state governments / UT administrations to expedite the process of appointments to the office of the presidents and members in the State Consumer Disputes Redressal Commission and the District Consumer Disputes Redressal Commission. Stop paragraph. The administration is directed to file a report indicating the steps taken apropos the aforesaid communication dated 6th November 2024. Stop. Let the report be prepared and circulated by 9th. List the matter on 10th.
Yes. Apply.
The original report by the Union of India be filed on the adjourned date.
Item number 5, double proceeding 39 of 2024.
My lordship, in this matter, I am appearing for the petitioner. My lordship, on last date, they had filed their affidavit in opposition. My client is a resident of Inter-Island. He could not come to me.
Resident of?
Inter-Island, Tiglifood. So for
Alright.
that reason, I am seeking extension of time to file affidavit in reply, my lordship.
How soon can you do it?
10 days, my lordship.
In days. Very well. Learned advocate representing the petitioner seeks extension of time for filing the affidavit in reply. Stop. On such prayer, time to file the affidavit in reply is extended till 20th December 2024. Stop. List the matter before the next circuit.
Okay.
Item number 6, double proceeding 41 of 2024.
Yes.
I have filed a rejoinder in this matter yesterday. So,
I have received it. I am ready with the matter. I am for the respondent number 5.
Respondent number 5. Who is the respondent number 1? Torun Kumar Roy,
Tarun Kumar Roy.
you are there?
I am for that. Yes.
So you are the respondent number 1 over here.
Yes.
What is the matter about?
third we did first, second, third.
All right. Is the respondent number 1 suffering an injury order or anything of that sort? What was your prayer before the tribunal?
Tribunal has granted the relief in my favor. Thereafterwards, they have filed an application for extension of time. For extension of time for compliance with the orders.
What was the order?
Yes, ma'am. The order is annexed. Last order. is with their affidavit in reply, my lord. Page 87.
Payment of arrears
Yes, my lord.
to the actual date within 45 days from the date of receipt.
The 45 days period has lapsed.
Yes.
Here afterwards, they have filed this MA application. That MA, after the MA application, they said they will comply with the order. Instead of complying with the order, they have filed the WPC. In the appeal, they have come.
Is it only the extension that they are challenging, or they are challenging the grant also?
They are challenging the order itself,
Order itself.
without mentioning that their MA application is pending before the tribunal. That has been allowed.
Yes, when will the matter be taken up?
Let it be tomorrow.
Tomorrow? Very good. On the prayer of the learned advocate representing the petitioners. List the matter tomorrow.
Obliged, right?
WPCP 44 of 134.
Your Lordship, my senior advocate Anjali Nag appears on behalf of the petitioner. I pray that this matter may be not today, Your Lordship.
Only not today.
Only not today.
Who is for the union?
We have one respondent, not union.
Which respondent? Administration over here? Who is for the union? Has it been served?
The union are not mandatory party, just like a, because before that, all the matters, they have to add union as a party, so they add union as a party and in a team or.
And nobody appeared for the union before in the tribunal?
Generally, there does not, in cases where union wants to represent, in certain matters, they write letters to the.
Here, who is the employer?
Administration.
Administration is the employer?
Who is the employer?
Police. All right, on the prayer made on behalf of the learned advocate representing the petitioner, let the matter stand over for the day.
Obligation.
Item number 8, MAT 16 of 134.
But in this matter, there are certain added parties at the later stage in the main dispute. Those parties have not been served. But I require to time to serve upon those parties. Because they have been added later on.
Who is for the respondent?
My lord, I am
You are
appearing
there?
for the writ petitioner respondent.
Writ petitioner. Are you aware of the addition of parties?
Yeah, it was there, my lord, before
Was
the, there.
And will you be representing the added parties also?
No, my lord, no.
There is-
Actually, the matter is very short, my lord. They don't have any case. Therefore, this matter, my lord will find that it was filed long back. It is listed only. Nothing is there, my lord, in this matter. Unnecessarily, they are dragging this matter. This was filed at least 4 to 5 months ago. They have not served the private respondent.
But they are not suffering for that.
We are suffering. We are suffering. There is an order. No.
This matter, what is this? There is a tussle between the two union. One is one union runs the autos with comprises of the identified persons, and one is of the who came from mainland. The union, the administration has taken up certain measures that you have to, in order to fly autos in the island, you have to be islander and all. You have to have a
Discrimination, my lord.
So there is a discrimination between was there.
That was negated by the writ court.
And the advocate representing the auto union, which are comprising of the islanders, they are not being served because they are serving required. They are treated at extent.
But then you are applying your autos now.
My lord,
Nobody is stopping all.
No, now they are stopping, my lord.
Who is stopping?
They are stopping, my lord. I have a document where the show cause was issued day before yesterday. I can place it. No, we know what we have to do, but my learned friend is not required to teach us what we have to do.
It's your, not to harass them when they are doing their business. On the prayer of the learned advocate made appearing for the petitioner. No, it will be the appellant. Appellants seeking time for serving copy of the appeal upon the added respondents. The matter stands adjourned till the next circuit. Stop service in the meantime.
My lord, obliged.
Item number 9, MAT 65 of 2024.
Appearing for the appellants, my lords. Lordship, this appeal, my lords, is against the impugned order of the learned single judge, wherein it was held that the tribunal constituted under the Maintenance and Welfare of Parents and Senior Citizens Act does not have the power to evict a tenant. That's the core subject matter of this entire dispute, my lords. The brief facts are, lordship, the appellants, there are two appellants, my lord.
Starting the matter, has the service been affected?
Service has been affected, my lords. On the 27th of November, affidavit of service has been filed. Copies have been served to the respondent, your lordship.
Nobody is appearing.
Nobody has entered appearance as yet, my lords. One Mr. K. Sabir was the advocate for in the writ petition, my lords, before the single bench.
All right. You can serve the learned advocate. Are you there?
I was appearing in the trial court, your lordship.
In the trial court, you were there? Will you accept copy?
Yes, sure. Let the copy, sir, lordship.
Counsel is there, please serve a copy upon him.
Obliged, my lords. I'll serve another copy upon him and it can be taken.
When will I list it?
Lordship, next second, your lordship.
Next?
Second, your lordship.
Lords, may I request for tomorrow, my lords, I will have the copy served today, my lords.
Next week,
Very well.
next week.
None appears on behalf of the respondent. Stop. Learned advocate for the appellants is directed to serve a copy of the appeal on the learned advocate who represented the
Single bench.
respondent before the learned trial court. Stop. List the matter on 9th, Monday.
Lordship.
Obliged, my lords.
Item number 10, MAT 67 of 2024.
Your lordship, I am for the appellant. Service has been affected to the Port Blair Municipal Council, but
All right.
I'll supply a copy.
Tomorrow,
There it is.
let a copy of the appeal be served upon the learned advocate representing PBMC. Stop list tomorrow.
Your lordship.
Item number 11, MAT 68 of 2024.
My lord, I am appearing for the appellant, my lord. First time this is appearing, registry may be directed to serve notice. I will put the requisite. Appeal is within time.
The matter is appearing in the list for admission. Stop. The registry की पाठा है एखाने?
Yes.
The
Mandamus appeal registry serving, I am.
registry serves.
Yes. I will put the requisite to Talabana. I will put the requisite to Talabana. Registry will serve.
This is the system. No? No, but otherwise, why don't you serve directly?
I can serve, no problem.
Please serve.
Yes.
Let copy of the appeal be served upon the respondents. List the matter.
Let there be direction for paper book. I will prepare it.
Paper book, let it be admitted first.
Obliged.
If it is not admitted on the very first day, it is dismissed. What?
Obliged. I will serve.
The administration learned advocate is here. I do not know whether he'll accept service or not. If he does, then it can be taken up.
Yes. There is one private respondent also.
Then serve.
Yes.
List in the next circuit.
Item number 12, effective of 124 with 10/3 of 124.
I pay for the respondent in this matter.
14th of November, this court, everything by and grant its limited restraint. And also call for the your report, but your report has not been notified as yet. And period of granting this case going to expire.
There was a specific direction to file paper book as well.
But then until the lower court records are available, how can the paper book be prepared? Lower court records? Ashit,
Paper book would be prepared by the appellant himself.
tomorrow, my officer says that by tomorrow the records will be here. So let the records come, देखिए order sheet है किया से. Oh, record has come, record has come.
Record has come. हाँ.
Notified by the registrar.
Very well, now you get to know that the record is here. Please inspect, prepare the paper book, but where is the order sheet?
Order dated 14 November 2024.
14th of November, yes. Sufficient grounds.
Paragraph 8 is for preparation of the permit after arrival of your court.
Yes.
Para 11 is the ST order.
Till 29th November it was.
2 weeks from date.
From the. Application filed
The
on
appeal has been
That's
disposed of.
2 weeks.
Disposal of the appeal. How can the appeal be disposed? Should be the application, isn't it?
18 is for,
Oh, yes, this is the order.
another paragraph of delay.
Yes. This is what I was wondering. How can it be disposed of? Please take down. The lower court records have since been forwarded to this court. Stop. Learned advocate for the appellant will be at leave to inspect the same and prepare the paper books. Stop. Copy of the same shall be served upon the learned advocate for the respondents. Stop. The interim order that is subsisting in the matter is extended till the end of the next circuit. List the matter immediately after the paper books are made ready. What is CAN 3?
And three for extension of.
Very well, CAN 3 stands disposed of.
Public.
Copy of 524.
At the instance of the writ petitioner, the matter is being included in the date list.
For what?
The interim order granted and pursuant to the order being passed by this court on the day when the interim order was granted, has been already been this week.
So for extension you want?
This matter can be taken up as there's several grounds. One such ground is non-adherence to principle of natural justice. The other side is agreeable. Next week, any day, the way matter can be taken. If I could demonstrate that lordship has not been heard, then the matter can be relegated back to the authorities for taking decision. But my building has been directed to be demolished. My building has been directed to be sealed. I have been asked to remove from this subject building, which can't be done under the local regulation under which the order has been passed. I have not been heard. The adverse materials were collected behind my back. It was not given to me before passing the order. It is only when the interim order was passed, communicated to me, for the first time I have come to know that certain adverse material have been used against me. It's all goes to the very root of the decision making.
Yes.
There was a direction by this honorable court to serve the respondent along with the copy of the writ petition and filed affidavit of service.
Are you not appearing?
I am appearing. I appeared on the last occasion when
Then?
it was moved unlisted.
Now you do
Thereafter-
not have a copy?
I have a copy.
Then what is your instruction? Where is the order of demolition?
See at page 68. The subdivision officer
Yes.
exercise the power of regulation 151. Now see page 68 and 69, these pages are the order in view. See,
A show cause was there.
I have filed the reply, I have responded it, they passed the order. But in the order in view at page 68 at the top, they have
Yes.
relied upon this report. This report have been given to me beforehand in course of hearing, so that I could have deal with it. Because the principle of natural justice is not simply secret giving a notice. If they are collecting any adverse material, they must ensure that I have an adequate opportunity to deal with it. When this order was given to me.
Are you using that property for commercial purpose?
This was raised long ago, and the rule under which, not the provision is, if it's an agricultural land, I have to seek for diversion. Use of
Conversion.
conversion, absolutely. But that rule has been struck down by this court in one of the cases.
All right.
So I'm not supposed to take diversion. If it's an agricultural land, I can use the land for the purpose for which I feel it proper. The rule has been struck down. It has been declared ultra virus by this court. The honor
Is it
states.
so?
Yes.
It can never be. On agricultural plot of land, you go on making construction and the rule is struck down. I doubt.
So the reason behind striking the rule is that it's not made in terms of the rule making power under the regulation 210. Regulation, there is no whisper as regards the rule. It is good subordinate legislation brought within the ambit of rule. It has not been, has no legal sanctity. This court considered it, it has been struck down.
No, but only committee has been struck down. He
Committee has been struck down.
now he has to
Where
obtain
is-
permission from the SDO.
And whereas the replacement
That's
is
what the
not
order-
satisfactory and the evidence of the diverted from agricultural, from agri to non-agri. Whereas tenant shall be allowed to be- Page 69. You have been directed to remove within 7 days.
Removal, lordship, demolition, sealing and restoration of land.
Everything, everything.
Save and except lordship sealing, rest have been stayed by the court. By this court, by an order dated 13 November 2024. Not see that. Sealing was drafted to be done, it has been sealed now. But I am on the main matter, lordship. If I could show lordship that this adverse material were used against me,
Do you have a copy of the report of the Tehsildar Mayabandar?
No, my lord, please.
Not there.
No, only I am having the copy of the writ petition,
Get hold of a copy of the report.
my lord.
What is there? Please come. The order of the subdivisional officer Mayabandar, dated 6 November 2024. Under section 151 within bracket 1 of A and N LR and LRR 1966 is impugned in the instant writ petition. Stop. Primary ground of challenge is that there has been violation of the principle of natural justice. Stop. Fair opportunity of hearing was not given to the petitioner. Stop. The document relied upon by the authority was not supplied to the petitioner. Stop. Paragraph. It appears that the petitioner was using agricultural land for non-agricultural purpose. Stop. It has been submitted by the learned advocate representing the petitioner that the land has already been sealed. Stop. The structure is, however, yet to be demolished. Stop. Paragraph. Learned advocate representing the respondent authority is directed to produce the copy of the report of the Tehsildar Mayabandar, relying upon which the order impugned has been passed. Stop. When will you bring it?
Monday,
Very well. List the matter on 9th.
plain copy of the order. I will- I
Which? Yes, this order will be put up in the server.
will- I send. Oblige, my lord.
Yes.
I would be appearing on behalf of respondent number 1.
One only. PBMC. Just give him a call. He must be here. Yes. What is the issue?
First, my lord, this petitioner was engaged as a delegated employee in the month of June 2013. He worked continuously, my lord, up to 2022. He was having some medical issues, therefore he was unable to attend the duties, and for that purpose he informed the authorities. Subsequently, when he recovered, he submitted duty report. He was not allowed to discharge duties. This is one issue. Second issue is that, my lord,
And the period of absence?
6 months.
6 months.
And he is a daily rated employee. Now, my lord, he worked for 10 years. It is an autonomous body, my lord. He works as a sweeper, my lord. Now, my lord, this period, thereafter, he was not allowed to join the duty, my lord, despite of the submitted duty report. Now, my lord, apart from that, in the midst of it, my lord,
So he has still not joined, permitted to join.
permitted.
22 was the last day of service.
Now, my lord, after that, my lord, he applied under Right to Information Act. Because there are one more issues there. My lord, the administration has promulgated a scheme whereby they decided that on from 1st September 2017, they will accord the benefit of 1/30th of pay to all those VRMs who are discharging the duties and responsibility of a regular employee for 8 hours a day. Now, my lord, in terms of the said decision, since he was discharging the duties of regular employee, if at all, he is not in service also, up to 2022, he has worked, he is entitled.
So from
for that.
17 to 22,
2022 he is entitled. Now, my lord, he made an application to that regard also. And after right to information, the information which he has gathered, the authority says that since you were not in service on the date when we accorded the benefit, therefore, unless and until there is an amendment or any order, we cannot give you that benefit.
where is that order?
That is in RTI, my lord.
Yes.
Can we see
two letters are there. First is under RTI, my lord, page 23.
Would you like to take instruction or make submission?
And not copy of the petition may be served.
Oh, you
But
don't
my lord,
have.
appears to be an industrial dispute, my lord. We should approach the labor
This is
system.
not at all, my lord, the issue was.
Similar
decided by-
matters, my lord.
Similar matter was decided by this court, whereby 1/30 was not accorded to other employees of the PDMC, my lord. And this court, they filed appeal before I filed a.
Even the daily rated Mazdoors go before the tribunal.
Labor court, last circuit only similar matter has been sent to labor court. Last
It has
circuit
been.
itself similar, but my submission, if my lord wants, my lord is inclined to entertain the petition, we will file our affidavit in opposition, let the point of maintainability. be
Listen, if it can be sent to the tribunal from here and now, what is the use of?
No, my lord, here it cannot be, my lord, because similar issue was adjudicated by the writ court, affirmed by the high court, division bench.
Very well, but then if the issue has been decided, then the principle will follow
Issue has
in
already
by
been
the
decided.
tribunal also.
And this maintainability point was taken before the writ court, before the appellate court. In both the occasion, it was negated by.
Come with the judgment.
My lord,
When?
and the benefit was accorded.
When?
Tomorrow itself.
Let a copy of the writ
Sir,
petition be
copy was
served.
served on 5th to all the respondents, 5th November, my lord.
Collect it from your office in that case.
It's a deliberated info, it's very difficult.
Yes. Or otherwise, he can make photocopy at his own cost.
Yeah.
At his own cost from the office, you can do it. Acha. To allow the learned advocate representing the respondents to come ready with proper instruction. Respondent to the learned advocate representing Port Blair Municipal Council to come ready with proper instruction in the matter. List the same on this Friday, 6th.
My lord, I serve the copy to the all official my lord. My lord, this petition pertaining to the seeking direction upon the response number 3 to dispose my representation. It is pending on 9/3/2023.
Page.
Page number. And it should be 14, my lord.
P14.
Yes, my lord.
Is it page 28? 29, P14, 19th of March,
Yes, my lord.
Assistant Labor Commissioner.
One number.
Conciliation proceedings are pending, my lord. This can be disposed of with the direction, my lord. We are requesting for 3
Conciliation for what?
industrial dispute, my lord. They have made a reference to the labor for the purposes of conciliation, and then later on it will go to the labor court when the
But then
reference.
Sanjupal Sajan, oh, he is the petitioner.
Yes. Kindly see the document, the last page.
Yes.
This is there is an industrial dispute. So, my lord, this matter is now pending before the conciliation officer. So, my lord, their relief that they have sought, kindly see the relief. They say.
He has
There is-
been disengaged from service.
The prayer
is the issue.
A at page 11 may be seen. The relief they are seeking is to complete the process which was initiated for conciliation proceedings in terms of letter dated 13 May 2024 within a period of 1 month. I am only saying that let it 3 months time may be granted.
But that was in May.
No.
From now
yes,
onwards.
Initiated, but the prayer is made on the day the writ, my lord, they are moving the writ now. So they are saying 1 month.
Anyway,
and it will
please
stick
come.
for 3 months, whatever lordship deals with. Severely understaffed, my lord, there's only
The-
one person. on the board.
Petitioner seeks a direction upon the respondent authority to complete the process for conciliation in terms of the application made by the petitioner on 13th of May 2024. Stop paragraph. As it appears that The prayer of the petitioner is pending consideration before the official respondent. Accordingly, the instant writ petition is disposed of by directing the Assistant Labour Commissioner to take steps for disposing of the prayer of the petitioner in accordance with law at the earliest, but positively within a period of 3 months from the date of communication of this order. Writ petition disposed of.
Item number 4, WPA 106/2024, filed from the petitioner, I served upon the respondent, but the private respondent yet to receive it. On 29, it was sent. President of Raleigh, I think Monday.
And for respondent 1, 2, and 3.
Very well. Learned advocate for the petitioner submits that service upon the private respondent is not complete. Stop. List on Monday, 9th. Service in the meantime.
Item number 5, WPA 93/2024. Lord, I am appealing for the petition.
Lordship, I beg to appear for the respondent Indian Oil Corporation. I beg to appear online, Lordship. Lordship, at the outset, I would like to submit that I have not been able to file my affidavit in opposition yet. I'm seeking for 10 days extension to file it, Lordship.
Previous objection, my lord, this is a tender matter. My lord, by violating all canons of law, my lord, they have allotted tender to a person, and my client is the sufferer, my lord, and my lord will find that repeated opportunity was given. I have served them thrice, my lord. Thereafter, they choose to appear before this court, and thereafter, one after another, they are seeking extension. My lord, the last extension accorded to them, my lord. Every time they comes and they seek for an extension, my lord. My lord, may kindly see the last order. My lord, if my lord, it comes to my lord may give them 2 or 3 days time, my lord, so that the matter can be taken in this circuit, my lord. Very short issue, my lord, very short issue.
Indian Oil Corporation is which respondent?
Lordship, respondent numbers 1 and 3.
1 and 3. In April 24, there was a direction for filing the opposition. We are in the first week of December, and still the opposition has not been filed. Why will the extension be granted to you?
Lordship, in April, the documents had not reached us in complete set.
After that, no, then they ask for first time such submission is being advanced.
What is the stage of the tender now?
Tender was culminated, my lord. When I approached this court by the time, because I have to serve them, they are in Calcutta.
So what remains in the writ
No.
petition?
I know to find that this tender, my lord, this is in complete violation.
I understand, but if the writ
My lord,
petition
it
was,
for 3 years, 2 to 3 years, my lord. Now it is 1/6.
My lord, find that the tender is not, the work which has been allocated is absolutely arbitrary, then in this case, the court can definitely interfere, and I have made him party also, the successful bidder. He is a party.
is the successful bidder represented by anybody?
No, repeat after this, despite of repeated service, my lord. I filed affidavit of service also. Please conclude that, my lord.
November 5th also, there was extension of time.
Lordship, the problem is, Lordship, the documents had reached the Calcutta office quite late. the Calcutta office of Indian Oil Corporation, and after affirmation and finalization only, it is ready, Lordship. It is just required to be sent to the Port Blair department. That is why, Lordship, I'm seeking just 10 days time so that I may send it over.
From Kolkata to Port Blair, does it take 10 days?
It takes hardly 2 days, my lord.
No, Lordship, not 10 days, but in case of any exigency, that is why, Lordship.
What is the exigency from April? The exigency is going on. I'll extend the time subject to payment of cost.
Lordship, kindly grant this as a last chance, Lordship.
If you take the court's order so lightly, then it is very difficult.
Lordship, the affirmation has to be done at Port Blair, because of which, Lordship, it's taking a bit of time, Lordship. Kindly considers this.
Learned advocate representing the respondent numbers 1 and 3 seeks extension of time for filing the affidavit in opposition. So, it appears from records that direction for filing affidavit in opposition was issued on 8th April 2024. Later on extended on 4th September 2024. On 27th September 2024. And also on 5th of November 2024. The same has not been filed till date. Stop. Today, prayer has again been made, seeking extension of time for filing the affidavit in opposition. Stop. Such repeated extension cannot be allowed by the court. Stop. Respondents ought to have filed the opposition within the time specified by the court. Stop. Since the affidavit of the Indian Oil Corporation will be required for the purpose of effective adjudication of the instant list, accordingly, time to file the affidavit in opposition is extended till 20th December 2024, subject to payment of cost of rupees 10,000 to be paid to the District Legal Services Authority at Port Blair.
Lordship may kindly grant this as a last chance, Lordship.
List the matter before the next circuit.
Obliged, Lordship.
Obliged.
Number 6. WPF 163 of 924.
My lord, I am appearing for the petition, my lord.
Yes.
I have filed my affidavit in reply today and I have served a copy to my learned friend. It can be taken up tomorrow or
For hearing,
for hearing.
but then it will come up in its usual course.
But
CDM has to be maintained.
Small matter
Very short issue is involved.
concerning the administration.
What is to be done? Or what is the difficulty?
My lord, the difficulty is, my lord, this petitioner was appointed as a office superintendent. He was discharging the duties of office superintendent on and from 2006 under the High Court. Subsequently, he was given regular appointment on 21st of December 2016, my lord. Now the next promotional post, because in between one post is there that is deemed demolition. So the next promotion post is Deputy Registrar Protocol, my lord. Now, for that, in terms of the recruitment rule, the requisite length of service is 8 years, my lord. Now, this incumbent is having only 6 years of service,
Regular service.
regular service, and he's the senior most, and there is no other incumbent to hold service. Now, the authorities have engaged a contract employee to look after the said affair. As per my prayer, my lord, first of all,
Let your past service be taken into consideration at the time of
consideration, and second, I say, my lord, at least on ad hoc, because I am going to be retired from next year, my lord. So there is no other regular employee.
the contractual one.
Contractual one is not an employee at all.
What is the stand of the High Court?
They say that because of the recruitment rule is 8 years, therefore it cannot be considered. My lord, kindly see. No, it's a legitimate expectation.
No, then,
First become eligible, then the
then,
question of
then,
eligibility.
yes,
Yes.
yes.
Individually speaking, I represent the High Court, so I have to speak very long. He is not eligible, he is not qualified. So he only has the right of consideration and he doesn't.
Did you consider this case?
Well, it was considered and it rejected because he does not qualify, my lord. It does
6
not-
years time
6
period.
And relaxation, my lord, that relaxation under the rules can be not with respect to the individual, it can always be with respect to a class of category, my lord. In isolation for a particular person, there can't be relaxation, but anybody, my lord, may feel appropriate, can direct it for his consideration. That's
Is the-
speaking.
No, my lord, I never said that I asked that promotion on regular basis. I say, my lord, I worked as an office superintendent from 2006. 2006. I am also the oath commissioner. But I have been given regular promotion only on 21st of December 2006. Now, my lord, my past service, if my lord sees, I have more than 15 years of service to the said post. I am not on that, my lord, but I am saying, my lord, either relaxation may be accorded or because I am the only person and I could have been accommodated as an on ad hoc basis.
Is there any provision in the service rules
My lord,
regarding relaxation?
relaxation, it is there. What has been fallen from my learned friend, that is the law. Relaxation cannot be given to an individual. My lord, I am just praying
Are you
for
ready with the service rules today?
service rule is there, my lord, but recruitment rules that will govern the affairs.
Yes, yes, where is it? Have
It
you
is there, my lord.
Page number 12 of my opposition.
12 of your opposition?
So far as the service rule is concerned, my lord, I am not having any departure from the said rule.
Unlike what we have in the rules of the administration, my lord. The High Court doesn't have it. Now, promotion is an internal arrangement of an organization, my lord. There one can't ask that I be given an ad hoc promotion or ad hoc
Yes,
staff.
please show me.
My lord, page 13.
Yes, 13, deputy registrar.
13, my lord, it says method of recruitment. An essential qualification, my lord, will get at page 7, clause 7, my lord. Should have possessed bachelor degree and so on. So this is for लेकिन गलत है. Actually, this rule is also, this ought to be in the case where it is direct recruitment. So far as promotion is concerned, my lord, it will not at all. Method of recruitment says selection from the willing and eligible officer of general branch working in the circuit bench of Port Blair on merits in terms of the rule of so and so as per the norms laid down by the High Court. Actually, in clause 7, they say.
This is the promotion and principle of seniority as per the norms laid down by the High Court.
Madam,
Yes.
this clause 7 says should have rendered at least 5 years of service as assistant registrar of general branch.
Where is the rejection?
Yes.
Formal rejection.
Has it been considered at all?
My lord, my prayer, my lord, may kindly see. I have asked for consideration only. I never said that.
That can be done.
Consideration only, my lord. And I say, my lord, I am the senior most regular employee. An incumbent who is not an employee, he is looking after the charge. So that may be considered, my lord. Only consideration I am asking, my lord.
Off the record, he is a good officer.
Please come.
18, my lord, see, I have categorically stated, my lord, that I am going to be. No, I am sorry, my lord. I am sorry, my lord, that is not the paragraph. My only prayer, my lord, this is past service.
The lower gate, the list of dates you have mentioned, 1996, he was appointed in the post of the lower grade clerk.
Not in,
Here, not in
no,
this
no.
organization.
Paragraph 3 onwards, my lord.
2003 is your first appointment.
Yes,
The petitioner was appointed as higher grade clerk in the establishment of the circuit bench of Calcutta High Court at Port Blair on 28th of April 2023. Stop. He was thereafter appointed as the oath commissioner relating to civil and criminal matters in the circuit bench on 6th March 2006. Stop. The petitioner was promoted to the post of office superintendent on 21st of December 2016.
my lord, only one thing, prior to that, from the para 9, my lord will find that he was discharging the duties of office superintendent on and from 2007.
2007.
7. Para 9.
Stop. The petitioner has averred in the writ petition that on and from the year 2007, he was permitted to discharge the duties and responsibilities of the post of office superintendent. Your retirement date, will you please show me?
My lord, my lord. I've stated, my lord, I'm just.
You mentioned 29th of February 24.
No, that was an incumbent who retired. I'm just.
About 4 years of service.
3 to 4 years, I'm just.
The petitioner is due to retire from service on, keep that place blank.
Yes,
Right. Paragraph, the petitioner submits that the post of deputy registrar within bracket protocol is vacant and the work of the said post is being done by a contractual employee. Stop. The petitioner seeks promotion to the said post. Stop. The prayer of the petitioner seeking promotion is yet to be formally considered by the High Court administration. Stop. Paragraph. Learned advocate representing the High Court administration submits and relies upon the affidavit in opposition, wherein it has been mentioned that the petitioner does not fulfill the eligibility criteria for being considered for the post of deputy registrar within bracket protocol. Stop. The petitioner, not the petitioner, an employee does not have a right to be promoted, and accordingly, the petitioner cannot seek promotion to a post for which he does not possess the requisite eligibility. Paragraph. I have heard the submission made on behalf of both the parties. Stop. It is settled law that an employee does not have a right to be promoted, but certainly has a right to be considered for promotion. Stop. Paragraph. It has been submitted that there is no other regular employee in the organization to be appointed on promotion in the post of the deputy registrar within bracket protocol. Stop. Paragraph. The work in question is being submitted to be performed by a contractual employee. Stop. Though the petitioner was appointed in regular service in the year 2000, when did you say regular service?
That is on 21st of December 2016.
On 21st of December 2016, but he was appointed. This was contractual from 2003,
He was discharging the duties of superintendent from 2007.
2007. Oh. But he was discharging the duties of the post of office superintendent from the year 2006. And by this time, actually 2007. And by this time, he has gained enough experience to be considered for promotion to the next higher post.
And my lord, this is admitted by them in paragraph number 12 of the opposition he was working from.
Stop next. In view of the above, the instant writ petition is disposed of by directing the
Registrar to forward it to the.
learned registrar circuit bench at Calcutta and a circuit bench of the Calcutta High Court at Port Blair to forward the prayer of the petitioner seeking promotion to the post of Deputy Registrar within bracket protocol to the learned Registrar General, Calcutta, for taking necessary steps for consideration of the petitioner's prayer in accordance with law. Stop next. The administration, the High Court administration is requested to take steps at the earliest and intimate the petitioner the fate of his prayer positively within a period of 6 weeks from the date of communication of this order. Writ petition stands disposed of. Did you get the
Yes, my lord. Paragraph number 28, my lord.
paragraph 28?
At the time of filing, I have said that only 3 odd years, my lord. Para 28.
You filed it in 24.
My lord, amended
Petition, you filed it in 24 only.
August 20.
August 20.
ওখানে একটা blank, there was a blank mention, he has only 3 years of service left. Disposed.
Employee.
Number 7, IQPS 697 of 2024.
Your Lord, Senior Miss Babita Das is appearing for official respondent, Your Lord. I pray for short passing.
I pray, I'm appearing for respondent number 4, which is the private respondent here. I would like to use my affidavit in opposition.
I am for the petitioner. Service has been effected. I have filed the affidavit of service also.
Let me see once. What is the matter about?
My lord, the thing is that my father is in occupation of some excess land prior to 1961. So it has been incorporated in the enforcement register also. 2003, the administration initiated a scheme to regularize the land under the excess land under the occupation of the pre-61 settlers. So my father died. The property was under the occupation of myself and my elder brother. My one sister who got married in the year 1966, she left for her matrimonial house. She did not come. The law of inheritance will not come in this. Whoever in occupation scheme says who are in occupation, descendants were in occupation, the land should be regularized in their name. But when the record was corrected and when the survey was made, it was found that I myself and my elder brother is in occupation of this said landed property. But when the license was prepared, the name of my sister also incorporated in the license. And my name as well as the name of my elder brother was wrongly incorporated. I made a complaint.
Wrongly by
Wrongly with a name wrongly means the
name was wrongly recorded. The correct name was not recorded.
All right,
So I have made a representation and thereafter the name was rectified.
all right.
Rectified. Then I
So
filed
that-
a representation.
The name of your sister.
Be deleted. Be deleted. Be deleted. Because the scheme says who are in occupation only.
How possession, how my learned brother is.
Law of
able to
initial-
have it. My learned brother says that I have left the possession. Since I've been married, so possession was not with me. It was a government property. 1961 survey was conducted. Then it was found that my father was in occupation of the property. Whenever it will be regularized in favor of descendants. So now.
Not only this, who are in occupation, descendant who are in occupation, scheme says.
Have you annexed the scheme?
Scheme, yes. Page number 15 is the scheme. Page number 15 is the scheme. No.
15.
Page number 15,
It's a letter, it's not a scheme.
Was once the excess land will be regular only to the extent that the concerned occupants and their descendants have maintained their continuous possession till date.
How possession can be anything,
Since-
symbolic possession, everything.
Since she's married, you'll throw her out?
No. That is not. The scheme says,
And the
if
scheme
it is
says-
recorded land, my lord, if it is a recorded land, certainly my sister is entitled to get a share. But it is a government land under my occupation. How my sister?
It was your father's land.
No, not the father's land.
Father was in the occupation of the.
1961. Thereafter, I am maintaining the possession.
Maintaining the possession.
Possession.
Sister, you want to throw her out?
No.
This is very
No, it is
unfair.
recorded land. If it is a recorded land, my father is having also recorded land. And she is certainly getting the share from the recorded land. But the scheme says that who are in occupation or when maintaining the possession, the regularization should be done in their favor.
Possession can be
Since
symbolic.
the, since the lady is married off, her possession will go.
Well, if no,
She comes to the house, you want your sister to stay with you? She will not go to the matrimonial home?
certainly not. Certainly not. No, my submission is that
No.
the scheme says.
You do not want your sister to be added over there. This is your specific submission.
My lord, my specific submission, law of inheritance will not apply in this matter, subject matter. Law will apply only if the land is recorded in.
If the law of inheritance not been applied, then the term descendant would not have been there.
Descendants, I am also descendant, but not only the descendant who are in occupation also.
Yes.
Descendants
So the law. of
have maintained their
inheritance
continuous
will
possession.
be there. But then the possession.
My lord, detailed
Let
hearing
us
is
see
required.
here once. Here is a brother who wants his sister name to be deleted from the records in respect of the excess land relying upon page 15. What is your submission?
It is the scheme.
Where is your application?
My lord, at page number 20. My representation is there.
My lord, you kindly come to page 17.
Yes, please.
The name of the tenant is there, no? Because at the time of inspection, that whether who else who are there in the suit in the landed property, so upon inspection, they found that these 3 persons were there. For that reason,
But
the
then
name has been
Pooja,
reflected in the report of rights.
Pooja
And
Devi, the third name that is over there, she is married.
he is married subsequently. Before that,
No, 66. Got married in the year 1966.
So that was not the idea for introducing such a scheme.
her name is there because she is the daughter. How
She's
is
the
daughter
daughter.
name? Even if she is married also.
Is the subject
It
matter.
cannot be done. Come up with something so that the writ petition can be thrashed out over here itself.
Thereafter, page 18, you know.
It has been done properly by you. This is the stand of the private respondent. The brother wants Pooja's name to go. Because she is staying somewhere else in the matrimonial house. Please come up with a report from your side so that it can be disposed of. Next week, I'll post it.
God bless.
The petitioner.
Recommendation letter and report.
Prays for deleting the name of the private respondent.
Death certificate, my lord, this name cannot be deleted.
It cannot be deleted. Come up with that right.
Death certificate of?
Death certificate of.
Pooja.
Name
You want to delete.
Pooja.
No, she's alive. My bloody sister is appearing.
How do we delete it?
She's alive.
If he wants to get his name deleted,
What did I
then
say?
he has to.
Question of legal error comes.
Private respondent from the land records as according to the petitioner, the name of the private respondent has been wrongly recorded. Stop. Specific case of the petitioner is that the regularization of excess land in possession of pre-1942 settlers is being done in accordance with the scheme dated 15th July 2003, annexed at page 15 of the writ petition. Stop. The petitioner contends that the private respondent is a married woman who does not stay at the subject land, and accordingly she does not have continued possession. Stop. Learned advocate representing the private respondent submits that as the land was originally occupied by her late father, accordingly on the death of the father, all his descendants would be entitled to be regularized in terms of the subject scheme. Stop. Learned advocate representing the administration submits that the name of the private respondent has been rightly recorded. Stop. Paragraph. Let a report by the administration be prepared and circulated by 9th, list on 10th.
WPS 647 of 124.
Yes.
This has to be decided on affidavit. If they are willing,
Yes, yes.
On behalf of respondent number 1, 3 and 4 in 8, 9 and 10, all similar matters.
All right. 1, 3 and 4. Principal Conservator of Forests. What is your prayer?
not, there is this scheme, because I'm an encroacher over a forest land prior to 1978. In view of the judgment of the Supreme Court, I have to be given an alternative land. And the portion where
You will vacate this land and it
they will
will
de-reserve it.
or
In the line of the
de-reserve.
ratio laid down by the Supreme Court.
All right.
They have identified the bona fide encroachers, my name do find in the list. They have to give effect to that list by giving a license for which the writ application has been taken.
What is the use of filing affidavit?
Not
What
the-
is there to file affidavit?
Yes, yes, Manoj, I'm ready with the matter. I haven't,
Where is your representation or your
not
claim?
that, not that representation consideration. I have brought this Andhra Pradesh State Transport Judgment of Supreme Court, which says consideration can be two-way. Simplicity consideration, I do not want that. My entitlement has to be recorded, and that entitlement, in the light of entitlement, they have to take it. Otherwise, they will reject it, my lordship.
Show me.
My lord,
It has to initiate from somewhere.
my lord.
Where is that initiation?
Yes. My lord. My lord, kindly turns to page 27. It's a list being prepared. I have obtained under the RTA Act, and my lord would find my name at serial number 177. 177 Muniai, and my lord would see the first serial number 170, the name, and then the last one. Accepted, limited to 1 hectares, considering the age of plantation crop.
177, page 27, I got it.
Page 27, yes,
Yes,
that's a
then
recommendation to regularize the land.
where is that recommendation?
This is part of the, this list is part of the recommendation. I'll just show that.
Show me the first
My
portion.
lord. My lord would see page 21.
Statement showing the particulars of enclosures.
Page 21.
identified by the committee received. Yes, page 21.
Is the list being prepared? My lord would say, find my name at serial number 17. My lord would see at the top.
Yes,
I made an application and at the top.
serial number 17.
Yes, yes. You have not seen the paper, it seems.
Yes, then
Don't borrow my words. And not the list which I have shown later on. These are the lists. I'll just show.
recommended list.
Yes, ma'am. Just one second. This is the first instance of list which I have shown. It's a recommended one for every village. Not see page 71. This has been prepared by the forest officials, revenue departments, page 71. Page 71.
Yes,
One would see the list. Several cases have been turned down on the ground that they do not fulfill the eligibility criteria. So far as my clients are concerned, her name has been recommended. This list has to be given effect to.
yes.
This has to be given effect to. If that is done,
Where is the question of filing affidavit?
no, it's not required. Because they may, before they would say this, I've said, Lordship, because they will say they have to verify the records. These
Let
are,
them verify it if it is
Yes.
already on record.
yes, yes, ma'am.
Let them verify.
Yes, ma'am, on Monday or Tuesday, ma'am. On Monday or Tuesday.
Wednesday, check up whether the name of the petitioner is there in the list recommended for. Copy of the writ petition is not there. The petitioner seeks for issuance of license in his favor in terms of the recommendation made by the committee. What is the name of this committee? Committee for?
Committee constituted for the purpose of regularizing this land
Committee for regularization
by the
of
encroachers for the forest area.
encroachers of forest land.
Yes.
According to the petitioner, his name has already been enlisted in the list for recommendation for regularization. Stop. Paragraph. Learned advocate representing the respondent number 2 is directed to verify. Is directed to file a report disclosing as to whether the petitioner has been held to be eligible for issuance of license.
But that will be done by, not by the forest department, that will be issued by the
You see his entitlement first,
forest area or not.
whether it is forest area, whether his name has been incorporated in the list for reservation. If you say he is entitled, then the next one automatically follows.
Correct.
What did I mention? On license on account of dereservation of the forest land. Stop. Such report shall be prepared upon verification of records by 10th December. List the matter on 11th December.
I'm grateful. I'm deeply grateful. Same order in other two matters also.
All right, same order. Will the appearance be the same?
Same.
You have a copy of the writ petition and everything?
Yes,
Please verify records.
yes.
Item number 11, WPS 659 of 2024.
Lordship, I am appearing for the petitioner, Lordship.
Yes.
Lordship, the matter is that the petitioner was allotted one floor space for running a Nescoffee stall in the Swarajdeep and Swadipdeep Island jetty or port.
This is without file.
Yes, do you have a copy?
Copy has been served physically, Lordship.
The original is yet to come from Kolkata.
Lordship.
Are you,
In the meantime, I would like to inform the court, my lord, that a meeting has been fixed on 4th of December, which is tomorrow at 11:38, where the case of this particular petition will also be considered along with some other firms, whether to
considered for what?
for extension.
Of?
His case is that his tender or not tender, his agreement to run those kiosks have not been extended.
All right.
So that has expired.
It's a limited period first.
Limited for a particular.
Tomorrow, the date has been fixed for consideration of your case along with others.
Lordship.
So request your client to be present at the time of consideration.
Lordship, of course. Lordship.
Where is the formal notice?
No notice was served upon the petitioner, Lordship.
Departmental committee, man, they'll consider, he won't.
Oh, the petitioner is not required to remain present?
Can I ask my client to visit the office today, Lordship?
My lord had taken up this matter in the principal bench.
Yes,
And my lord had granted them limited protection, my lord.
till second.
Till second.
No,
That's
that's not
It
there.
has to happen tomorrow, my lord.
Again, tomorrow nothing is. The writ petition is, has been dispatched. The writ petition was filed in the principal bench at Kolkata and at Calcutta. And the same has been dispatched from Kolkata, but is yet to arrive before this bench. Stop next. The learned advocate representing the administration within bracket Port Management Board has brought to the notice of this court that to discuss and finalize the application / requisitions received from various firms for temporary allocation and extension of already allocated open / covered / C space within bracket S in A and N ports / port limits, comma, a meeting has been scheduled tomorrow at 11 a.m. in the chamber of the manager within bracket cargo operations. Stop. The court has been informed that the prayer of the petitioner seeking extension will also be taken up for consideration tomorrow. Stop. Next. In view of the above, let the matter be listed on 9th.
Lordship, the one intelligence, Lordship, the interim order for not to take any coercive decision.
A report shall be filed by the Port Management Board on the adjourned date. They will not take any steps.
Interim order be extended, Lordship.
There is no interim order as such, but then.
Yeah, there was an interim order not to take any coercive step until the decision is made by the authority.
So decision is yet to be taken by them. Please wait. They won't take any steps. The council is assuring the court.
Okay, Lordship. Lordship, grateful, Lordship.
Item number 12.
My lord, I am appearing for the petitioner, my lord. Without hearing me, my lord, this writ petition was dismissed, my lord.
Dismissed
Dismissed.
on merits.
Dismissed.
On merit.
On merits, without hearing me. My lord, may kindly see, even my lord, when the matter was, just a minute, this is my application. What happened, my lord? Even when the matter was over, I went to the court and requested, my lord, I may be heard on merit. But the court refused. My lord, may kindly see paragraph number 4 of my application.
1 minute. The order dated 5th November, you seek recalling.
My lord,
I see the advocate's name for the petitioner is
my
recorded.
junior has short for time, my lord. Para 4, my lord, may kindly see para 4 of the application I filed.
This application, the nomenclature used is for setting aside the ex parte order.
Yes, my lord, it's an ex parte, my lord. I have
You ought to have preferred an appeal if you are aggrieved.
my lord,
The application is not the proper procedure.
my lord, kindly appreciate, my lord. I was not heard at all, my lord.
Maybe, even if you are aggrieved, you can prefer an appeal.
My lord, kindly appreciate the situation, my lord. I was in court number 1.
I follow, but then what you have prayed for can be.
My lord, it's an ex parte order. It ought to
By the. Not setting aside, if you seek for recalling, then it's something else.
that I am before a writ court, my lord. I am not.
This expression setting aside of ex parte order.
That can be amended, my lord. That can be amended, my lord. But my lord, that can be amended, my lord. That can be amended because here what happened, my lord? 2 of the family members of this petitioner succumbed to death in an accident whereby a tree has been fallen over their house, my lord. And my lord, the administration took 4.5 years for filing their affidavit in opposition.
See, the court has come to a conclusion.
And the conclusion is contrary to the documents which are there.
A very good ground for preferring appeal.
My lord, but I will be losing a forum, my lord. Can you appreciate this?
You have been heard or decided on merits.
No, my lord, I was not heard, my lord. Kindly appreciate the situation. I have categorically said. My lord, it can be recalled, my lord, and it can be heard today itself.
File recalling application. This cannot be allowed. Please come.
My lord, in that case, I will withdraw it. The certified copy may be given back. So that tomorrow itself I can file an application for recall.
An application has been filed by the petitioner praying for setting aside the ex parte order dated 5th November 2024 and to restore the writ petition to its original position. Stop. The court has expressed the view that such prayer cannot be allowed by a coordinate bench, and the proper remedy of the petitioner ought to be before the honorable division bench. Paragraph. Learned advocate for the petitioner seeks leave to withdraw the application and file an application for recall. I do not know whether that will also be.
Because my finding is that
yes,
recourse would be before the division bench.
Yes,
that
so
is,
it is better you do that because the recall will also not be maintainable.
Yes.
Stop next. We don't mention that withdrawal part. We'll delete that line. Stop next. In view of the above, the application being Can 1 of 2024 stands dismissed. Stop. It will be open for the petitioner to take proper recourse to law for challenging the order dated 5th November 2024.
My lord, the certified copy, my lord.
The original certified copy annexed to the application be returned to the learned advocate for the petitioner by retaining a photocopy of the said order.
Obliged.
In a disposed of matter, interlocutory applications are not
But my
entertained.
lord, the difficulty is that it's
That's
fact.
the difficulty.
Item number 13.
Your Lordship, I am for the respondent.
BSNL,
Yes, I don't know what is
Petitioner.
petitioner. Mr. Vijay Kumar used to appear once, but thereafter, I
it's a
think,
2021 matter.
yes, Your Lordship,
Can
actually,
has been filed.
yes,
What
actually,
is the can for?
can was, I'll just explain in short, Your Lordship. Petitioners filed the writ petition because they were not getting the payment. They said BSNL should be directed to make the payment to the contractor concerned because it was through contractor.
Yes,
And order was passed that you have to pay to the contractor, clear the dues. We have paid to the contractor, clear the dues. But the contractor, what he has done, he stopped paying the amount to the EPF because he was required to make the payment to the EPF. We filed an application that we may be directed to deduct the EPF amount so that we can, because responsibility is upon the principal employer. So we were directed to deduct the amount and make the payment directly to the EPF. This honorable court disposed of the CAN application and ordered accordingly. Now the matter is fixed for hearing of the writ petition.
if nobody comes, then
Yes,
it
Your
will be
Lordship.
directly dismissed.
Let it be.
Did you deduct?
Yes, Your Lordship, we have
20
now the problem is if writ petition is dismissed, my application where that order has been passed, that also will become infructuous.
No. Why? You have already given effect to if the petitioner does not proceed.
Already done that application which we have filed.
Very
for
good.
deducting-
Post it one more time in the next week. If nobody comes, then it can be dismissed.
Yes.
Because 12th November, I see your presence is there, but the petitioner was not there.
Yes, they're not appearing since a very long time.
But then it's Anushka Singh.
No, she's also for BSNL only.
Oh,
She's my junior.
It has been recorded for the petitioners?
No,
Recorded.
yes.
Respondent number 1 for the private respondent, respondent number 1 for the private respondent. None appears on repeated occasions.
Yes.
24. And does Mr. Vijay Kumar practice over here?
Yes, Your Lordship.
Even notice to him
I informed him.
so that he can come.
Yeah.
Otherwise, I'll dismiss it.
Yes.
None appears on behalf of the petitioners at the time of call. Stop. It appears that the petitioners are not entering appearance for the last few occasions. Stop. One last chance is given to the petitioners to make appropriate submission. Stop. In the event none appears on 10th December 2024, when the matter will appear in the list,
Vijay Kumar.
the next party order will be passed.
Obliged, Your Lordship. So next circuit पूछेंगे सर मैं बता देती हूँ सबमिशन करके.
Item number 14.
Your Lordship, here, Your Lordship, this petitioner participated in a examination held for first year MBBS course. Now, Your Lordship, that was her last attempt. There was a notification by the Government of India dated that NMC 1st August 2023, whereby new guidelines were framed. Now, there was an amendment to the new guidelines on 1st September 2023. Written examination of the petitioner was held in July and practical was held on 11th September after the amendment. The point was that whether after the amendment that guidelines will be applicable or the older one. Now, Your Lordship, Kerala High Court has already decided this issue and benefits have also been given to the students concerned. Division bench of the Madras High Court is in session of this particular issue. I have already submitted on the last occasion also. So the matter is going to be heard in this week or next week, Your Lordship. I am praying let it be in the next circuit. Because once that is decided, Your Lordship.
Learned advocate appearing for the petitioner submits that the issue in question is pending consideration before the Madras High Court.
Your Lordship.
Stop. Prayer has been made for adjourning the matter till the next circuit. Stop. On such prayer, list in the next circuit.
Your Lordship.
Right.
Good, I am for the petitioner
There was a direction.
for filing affidavit, my lord.
Application has
14th.
been prosecution, my lord, for this statement. My lord, then, my lord, we were required to file the affidavit in response to that, my lord.
That period is already over.
Morning, I received papers, my lord. I am requesting for a short extension, my lord. Some time maybe.
1 week was granted on 14th November.
I know, I just now received
14th
the
of November.
first extension, my lord. I received the documents, my lord, just now. Praying, my lord, if some time may be granted.
My 20-year structure was demolished without giving opportunity available. And the people who are
But it's
encroach.
not on the merits, my lord. Today, my lord, is the application where he's seeking prosecution, my lord. So I'm
Yes.
trying to respond to his allegations.
You failed to respond in
No,
time.
I'm praying for an extension.
Page 28 may be seen, my lord.
Please come.
There was some time, my lord. Short extension may be granted. I'm asking for notice.
Learned advocate representing the Tehsildar seeks extension of time for filing the affidavit as directed with the order dated 14 November 2024. So, time to file the affidavit is extended till 10th of December. Will be all right with you?
It's fine.
In that case, it will go over.
My lord, within this circuit, my
Would
lord.
like to reply. I'm sure they would
Reply.
like.
I
to
will
reply.
take only 1 day.
15th
Everything
is
is-
a Sunday. It cannot be done.
Prior to that, my lord.
Let, we may be granted time till 9th. 9th, oh, sorry. 11th.
My lord, may I submit?
Yes.
In the event of death, I want to die before this court.
No, I will not. I am not here to kill you.
This may be fixed in this circuit, my lord.
Till the 16th. We spread till 15th till the 16th.
So that this circuit will be skipped.
Somebody else will be there.
My lord, already 14th November order was passed, 1 week time was granted.
I see it.
Very serious matter.
Serious matter, yes.
It's extremely serious. This is
Serious, my question of my survival is
right,
gone.
right.
Question of someone's life and liberty is there.
16th.
Prison if he-
Reply.
12th, my lord, 12th, my lord, may fixed on 12th.
Reply if any by prior to the next circuit. List in the next circuit.
Blazed.
Item number 16, the contempt of an order passed by Honorable Justice Joy Shengupta.
16.
16. I'm sure they have to.
Very well.
The registrar be directed.
The contempt arises out of an order passed by His Lordship, the Honorable Justice Joy Shengupta. Stop. The registrar of this court is directed to place the file before the Honorable Judge.
Obliged, my lord.
Item number 17. WTA 133 of 2020.
My lord, my senior is appearing for the petitioner. I pray for short passover may be given.
Passover in a hearing matter.
Not today, then, madam.
Why don't you start? It's a matter of 2020. I'm not an advocate on record. May not be the advocate on record, so what, you can start. You can open the brief. Have you gone through the brief? No, no, my lord. Go through the brief if possible. My lord. I'm adjourning it for the day. My lord. An accommodation has been sought for?
My lord, I'm.
Oh, there you are. Yes.
Actually, there one password matter is there, my lord, that's why. My lord, the issue is here. This
You-
petition,
Yes.
these petitioners, my lord, the background of the case is that these petitioners were initially engaged as a daily rated employees under the forest department, my lord. There are numerous persons, more than 100 and odd persons. Now, my lord, after their appointment, my lord, they filed a industrial dispute before the conciliation officer seeking two remedies, my lord. First, they are entitled for the benefit of 1/30th of pay. Second, to regularize their service since they are working for years together. My lord, union has pursued the said case. Now, my lord, the conciliation ended in failure. The appropriate government referred the matter before the labor court with the aforesaid two reference, my lord. After a full dress trial, my lord, labor court adjudicated the issue and said that they are entitled for the benefit of 1/30th of pay from the date of their initial appointment. Because, my lord, there is an office memorandum of Government of India, 7 June 1988, which was promulgated in terms of the judgment passed in the case of Surinder Singh versus Chief Engineer CPWD, my lord. So, taking into consideration that office memorandum, that issue was decided, they are entitled from the date of their initial engagement. Now, my lord, when the case was filed before the labor court, actual date of initial appointment, and since union has taken up the issue, dates were not available. So therefore, the court said from the date of the initial engagement. And so far as the regularization part was concerned, the court said the authorities may at their domain consider the same. And if they are otherwise eligible. This was the order of the labor court. They challenged it before the writ court. Writ court dismissed their petition. They challenged it before the division bench. Division bench dismissed their petition. They filed an SLP before the Supreme Court. When they filed the SLP and when this was pending, my lord, in order, they accorded the benefit of 1/30th of pay. Labor Court's award was 15th July 2005.
And when was that award passed?
15th July 2005. Award was passed on 15th July 2005. My lord, thereafter Uma Devi judgment came and regularization, there is another writ petition that I will argue so far as regularization is concerned. Now, my lord, this date, thereafter SLP also, my lord, since they had regularized their service and all, the SLP was also withdrawn by them. The court has held that there is no live issue in it, therefore disposed of. Now, my lord, in this writ petition, we have sought for the benefit of 1/30th from the date of our initial engagement. This is the issue in this writ petition. Already, my lord, the matter was.
Please stand in the opposition.
They stand that we have granted it from 2010.
Why? What is the reason? 10,
No reason has been assigned because.
8 and 12.
My lord, because they are state, they can do anything, everything, my lord. That is their stand, my lord.
I'll hear you.
My lord, I will show only the award of the labor code because they cannot travel, we cannot travel beyond the award of the labor code. Now, my lord, may kindly see page 29 of the writ petition.
Yes.
Now, my lord, 29. My lord will find the award is dated 13th July
2005.
2005. And my lord, the question of regularization was not raised in this writ petition only because, my lord, I had filed a contempt application. That's why otherwise, for that, now I am taking another writ petition for regularization.
This is only for the minimum wage.
Minimum wages, that is. Now, my lord, 13th of July 2005 is the award. Now, my lord has to see there are two references made by the appropriate government under section 10 of the Industrial Dispute Act, page 29. The reference, my lord.
Yes.
We are confined to Roman 2, my lord. Whether the demand of the general so and so for payment of 1/30th of the minimum of the relevant pay scale to 136 workers as per office memorandum dated 7 June 1988 of the Government of India, Ministry of so and so is legal and justified. Now, my lord, the finding of the court, my lord will find. Kindly come to. My lord, may kindly come to the operative part of the award, my lord, page 41.
Yes.
My lord, this is the operative part. Now, my lord, may kindly come to Roman 4. It says all the other 22 workmen appearing at serial number so and so, 122 workmen, are entitled to get daily wages at the rate of 1/30th of the minimum of the relevant pay scale plus DNS allowances in terms of the Government of India's Office Memorandum dated 7 June 19 from the date of their initial engagement till 31/8/1993. Well, this 31/8/1993 is for those workers because there are the numbers are there who have been given status in terms of the temporary status scheme, my lord. 1/9/1993, there was a temporary status scheme, my lord. So apart from that, 122 workmen, because there are total 136. The court said all the other 122 workmen are entitled for from the date of initial engagement. Now, my lord, the law is such, my lord, that it is applicable after 7 June 1988, who have been appointed. They are entitled from the date of initial engagement, my lord. And this issue, my lord, because since this award is in my favor, no other judgment is required. But my lord will find there are numerous judgments of our court, which was not interfere up to Supreme Court, whereby the court said you have to pay it from the date of initial engagement. In one of such case, my lord, when it was presided over by my lord Justice Sanjeev Banerjee, my lord, in a division bench, there was an order by my lord Justice Sanjeev Banerjee to pay it from the date of initial engagement, and my lord said the very purpose of the notification is such that it ought to be from the date of initial engagement. They went to Supreme Court. In Supreme Court, when it was about to dismiss, they said we will file a review application before the division bench. They once again came before the division bench and argued. My lord has clarified that it ought to be from the date of the initial engagement. Now, my lord, here there is an award in my favor, which says from the date of initial engagement. And my lord, thereafter, my lord will find the order of the writ court law, my lord, I have enclosed that is not required because those writ petition and appeal, everything was dismissed. Now, my lord, may kindly see the order whereby they have accorded the benefit at page 56.
Yes.
Now, my lord, this is the order, my lord, whereby they have granted this benefit. They say that, my lord, 136 daily rated workers in ID have inter alia paid for payment at the rate of so and so in terms of so and so notification. The Industrial Tribunal, Andaman Nicobar Island, in its award dated 13 July 2005, has ordered that the daily rated are entitled to get at the rate of so and so DNS allowances. Now, my lord, they cunningly they have not written from the date of initial engagement here. The award of the Industrial Tribunal has been challenged in the Supreme Court by the Department of Finance. The matter is yet to be heard in final order issued by the Honorable Supreme Court. Meanwhile, the Bharatan Workers Union, through representative dated so and so to the Lieutenant Governor, requested for implementation of the award dated so and so. The representation has been examined, and the Honorable Lieutenant Governor is pleased to order payment of daily wages at the rate of 1/30th of the minimum plus so and so to the 136 DRMs who are presently posted in Avalon with effect from 1/4/2010, without prejudice to the right and contention of the administration in the special leave. This payment is subject to the condition. So this is the order. Thereafter, no order was passed, and in terms of this order, they have accorded, my lord.
SLP order.
SLP order is there, my lord. SLP order is page 62, my lord. We have pursued the present application in view of the subsequent order of the court in regarding to entitlement of payment. We do not find any live issue for adjudication in this appeal. Now, my lord, at this junction, after the orders of all the court, whether they can travel beyond the award, my lord.
Please show me from the affidavit in opposition what is their stand.
My lord. Page number 11 of their opposition, my lord. S.
Yes.
This is their stand, my lord. Got it, my lord?
Yes.
It says that the petitioner, after accepting the 1/30th of pay at the belated stage, after a gap of 6 years from the date of the award dated so and so, passed in ID case and after order dated so and so passed by the Honorable Supreme Court has filed the case before the court for release of arrears of the relevant pay scale and on the date of initial as said the application filed by the petitioner is illegal, bad in law and barred by limitation. Now, my lord, first of all, my lord, it's a settled law that, my lord, if a continuous wrong is caused and which is not affecting any other person, in that case, my lord, the delay will not come, the limitation will not come. This is a settled law, my lord. The leading judgment in this is Tarsim Kumar versus Union of India, my lord, 1998 Supreme Court judgment, my lord. Now, my lord, apart from this, it is not that we were, after this order of the Supreme Court, we were sleeping, my lord. After the order of the court, my lord, we approached the authorities, my lord. I will show from the page number, my lord, may kindly come to page number 63 onwards, my lord.
Of the opposition of the writ.
No, of our writ petition, what we have done, it is not that we were not pursuing the matter.
Yes.
My lord will find that we have written after the order of the Supreme Court, we have written a letter to them to comply with the order of the Labour Court. Now, my lord, go to the next page. Thereafter, one more representation, thereafter contempt notice. Two contempt notice, even to the administrator, the contempt notices were issued. Thereafter, once again, letter 2016 implementation of Labour Court Award. My lord, we were pursuing, ultimately we filed a contempt petition. Now, my lord, the award of the Labour Court was affirmed by the writ court. So, writ court has not passed any order. Therefore, on the said score, that contempt application was dismissed. Contempt would not have lied, my lord, but it is not that we were sitting tight over the matter, my lord. We were pursuing with the authorities. And, my lord, when it's my right in terms of the.
Very well.
My lord.
Nothing else.
No, no.
And not may have the written, we have filed this points of submission, my lord. Initially, when at the state matter was before the division bench, we had filed points of submission.
But it must be there in your opposition.
No, I'm
All
just-
points must be there in your.
No, that was with regard to, no, just a minute. What happened, my lord? These matters there were several matters tagged together. So this matter was also tagged together. When, my lord, division bench passed order in my favor in those cases. So I said before the division bench, my lord, will dispose of this on the said score. Then the division bench said they will losing an opportunity. Thereafter, a hearing was conducted whether it can be referred to single bench or the division bench. For that, my learning friend has submitted the.
I'm only relying on it for the convenience of the, I'll give a copy. Just for convenience of the court, I'm relying upon this. I understand that it was for a different purpose. Kindly see, my lord, because the entire chain of events will make it clear, my lord, what the issue is before your lordship.
Yes.
First paragraph, the present writ petition has been filed seeking writ of mandamus directing respondent authorities to act in terms of an award dated 13 May 2005 and to release arrears of 1/30th of pay at the minimum of pay scale, dearest allowance plus for 8 hours work day in terms of office memorandum. Now kindly see second paragraph. This is a general legal proposition, my lord, that it is the onus is always on the worker to establish that he has carried out work of regular nature and therefore is entitled to 1/3. Now kindly see the chain of events on the second page. By an order dated 13 July 2005, the Industrial Tribunal was pleased to hold that 122 workmen were entitled to 1/30th of pay in terms of office memorandum. This is affidavit of opposition, page 19, but my learned senior has shown page 42. Kindly have the operative direction once at page 42, which was the award of the Labour Court, which was shown. The operative direction is at page 42 of the writ petition. The corresponding page of the affidavit of opposition is mentioned in the note. All the 122 workmen appearing at such and such are entitled to get daily wage at the rate of 1/30th of pay at the minimum relevant pay scale plus dearest allowance in terms of office memorandum dated 7 June 1988 from the date of their initial engagement till 31st August 1990. There is no dispute. This is the direction of the Labour Court. Now kindly see what happens after that. If my lord has the note again. This order was challenged by the administration by way of writ petition. The writ petition was dismissed. That there is also no dispute on that. The writ petition was dismissed. So the order of the Labour Court attained finality so far as the Honorable High Court is concerned. Now what happens after this is, my lord, that order of the writ court, which is the order of the Labour Court, merges into the order of the writ court, and that order, my lord, is challenged before the Supreme Court. So, my lord, before the Supreme Court, special leave petition is preferred. Now, if my lord has the note, during the pendency of the special leave petition, the following developments take place. The department, on approval from the Lieutenant Governor, granted payment of 1/30th of pay at the minimum of relevant pay scale plus DNS allowance to 136 daily rated Mazdoors with an order dated 31st March 2010, subject to the condition that the SLP pending before the Honorable Supreme Court is disposed of in favor of the administration. This is page 37, and the corresponding, my lord, page 56 was shown by my learned senior. Page 56 is the order. 31st March, kindly have that document once more, page 56 of the writ petition. Now, my lord will find over here that specifically, my lord, the order records, kindly see the second para. Meanwhile, the Baratang Forest Workers Union, through representation number such and such, addressed to Honorable Lieutenant Governor, requested for implementation of the Industrial Tribunal's order, same award. The representation has been examined, and the Lieutenant Governor is pleased to order payment of daily wages at the rate of 1/30th of pay of minimum relevant pay scale to 136 daily rated Mazdoors with effect from 1st April 2010. So while the Liz is pending before the Honorable Supreme Court, they make a representation to the administration saying that you implement the award of the Labour Court. And when this representation is made, pending the challenge filed by the administration before the Supreme Court, the Lieutenant Governor grants the benefit from a different date, that is 1st April 2010. Now, this fact, my lord, if my lord comes back to the note, subsequent to this, what also happens is, my lord, that ad hoc appointment is given to 122 numbers, 122 numbers of daily rated Mazdoor is appointed, effective regularization is given. Now, that document, my lord, will find at page 39 of the affidavit in opposition. Kindly have, my lord, page 39 of the affidavit in opposition. So 1/30 benefit is given, and then, my lord, benefit of regular appointment is also given, my lord, at page 39. So, my lord will see page 39 of the affidavit in opposition, 21st May 2015 is an appointment order, whereby, my lord, regular appointment is given to the DRMs. And this process was carried out through a proper, there was also a selection process carried out. And several of the members of the union also got appointed as regular Mazdoors. Now, kindly see after this, my lord, we have the note again. Meanwhile, the petitioner union filed an application for direction in the Honorable Supreme Court, which was registered as interlocutory application number 6 of 2015 in civil appeal number 7177 of 2009, wherein it was submitted by the petitioner union that the Union of India has complied with the notification dated 7 June 1988 and have extended the benefit of 1/30th of pay along with dearness allowance to all daily rated Mazdoors and praying issuance of directions herein as the appeal has become infructuous. Now, kindly see page 48 of the affidavit in opposition. This is their application, which they have filed before the Supreme Court. Page 45 it begins. Now, kindly have page 48, paragraph 7. That the applicant respondent states that since the concerned appellant, that is the Union of India, has complied with the notification dated 7 June 1988 and extended the benefits of 1/30th of pay along with dearness allowance to all daily rated Mazdoors working under the appellant in Baratang division, whose names were included in ID case number 3 of 2002. So therefore, my lord will say, kindly see the prayers which are at page 51. Allow the present application issuing appropriate direction upon the appellant as the appeal has almost become infructuous. So they may file an application before Supreme Court recording accord and satisfaction with the steps taken by the administration with respect to payment of, as my learned senior is not agitating regularization, so far as payment of 1/30 is concerned, they file an application on affidavit. They say
that we are satisfied with the appointment which has been given. And this appointment was a without prejudice arrangement which was entered into by the administration pending the SLP. So the union files an application before Supreme Court saying that there has been accord and satisfaction. We are satisfied with the benefits which have been conferred. Now, in view of this application, the Supreme Court passes an order. Kindly have now, my lord, page 53. This order was also shown from, I think, in the writ petition, it was at page 62. Now, kindly see, my lord, what the Supreme Court says. We have perused the application, which is their application, seeking appropriate directions in view of subsequent order of the government with regard to entitlement of pay of the respondents. We do not find any live issue for adjudication in the appeal. The civil appeal is therefore disposed of as infractions. So, my lord, two submissions. First, there is accord and satisfaction. It is a private, the private party makes files on affidavit before Supreme Court which have been given. In view of that, the Supreme Court says that now no live issues. What was the live issue? What was in challenge before the Supreme Court? The order of the Labour Court, which was affirmed by this honorable court, was taken up in appeal before the Supreme Court by the government. So therefore, what was an issue? The benefits that were given by the Labour Court were a live issue before the Supreme Court. In those proceedings, the parties enter into an understanding. The administration issues an order. The union files an affidavit saying that we are satisfied with the financial benefit. What was the financial benefit? Financial benefit was given from 1st April 2010. So, my lord, the order of the dispute between the parties is settled before the Supreme Court, and the Supreme Court passes an order saying that there is no live issue surviving. So, first point, my lord, there is accord and satisfaction. So, my lord, note they cannot subsequently try to clearly stop from subsequently contending in other proceedings that they are entitled to anything more. Second contention, my lord, the issue regarding the issue that they are now trying to raise is barred by res judicata. Because, my lord, the Supreme Court has said in the order disposing of the civil appeal that all disputes are settled, nothing else survives in view of what they have said in their own application. So, my lord, today, my lord, the issue regarding the date from which, that is the issue which was agitated inter alia by the department before the Supreme Court also. Department was in challenge against the order passed by the Labour Court in its entirety. So, my lord, today neither party can file a subsequent proceeding where the matter has attained finality before the Supreme Court to then again try to go behind the Supreme Court's order and say that no, the Labour Court had granted something more. When the Labour Court's order was in jeopardy before the Supreme Court, and the Supreme Court, based on the consent of the parties, or even otherwise, this order doesn't say it's based on consent of parties. It says based on what is stated in the application. Be that as it may, this is the final decree that is in existence today. So how can this gross abuse of process to try to agitate the same thing after it has attained finality before the Supreme Court? So, my lord, my humble submission is that no cause of action has survived, my lord, after that. And this, my lord, they have written some representations, etc. after the Supreme Court's order. Now, those kindly see the decision, my lord, in the representation. Our stand is fully consistent, my lord. We'll see page 54 of the affidavit in opposition. Kindly see page 54. Page 54 of affidavit in opposition. Kindly see the order dated 21st July 2016. The whereas 136 daily rated Mazdoor Baratang Forest Division in ID case number 3 of 2002 have inter alia prayed for payment at the rate of 1/30th of pay at the minimum pay scale. Whereas after adjudication of the case, the industrial tribunal had ordered that they are entitled to get daily rated daily wages. Agreed by the award of the industrial tribunal, administration moved this honorable court, honorable high court, which was dismissed. Agreed by the department. The department moved the honorable Supreme Court. Whereas, kindly see the fourth recital on page 54. Whereas the Baratang Forest Workers Union in the meanwhile had represented before the Lieutenant Governor for implementation of the industrial tribunal's award. So the representation was for implementation. It's not as if it's a separate issue altogether. It is a implementation of the industrial tribunal's award, which would within its scope include any further compromise or adjustments by the parties, which was also disposed of by the Honorable Lieutenant Governor, Vide Department of Environment Forest, such and such, dated 31st March 2010, with the direction that payment of daily rated daily wages at the rate of 1/30th of pay at the minimum or relevant pay scale plus DNS allowance to 136 daily rated Mazdoor of Bharatang Forest Union, some of whom with effect from 1st April 2010, without prejudice to the rights and contentions to aid and administration, SLP filed before the Supreme Court. Subject to the condition, this is the last part is not relevant. Whereas the apex court, while disposing of civil appeal, has observed that in view of subsequent orders of the government, which is the 31st March 2010, with regard to entitlement of pay to the respondents, we do not find any live issue for adjudication in this appeal. Whereas the implication of order dated 19th February 2016 of the apex court in the aforesaid matter was further examined by Law Department, which concurred in the opinion granted by Advocate on Record, Supreme Court, and stated that apex court, having recorded with the subsequent order dated 31st March 2010 of the administration in regard to entitlement of pay, the award dated 31st July 2005 accordingly stands modified to the extent competent authority, after careful consideration, is the view that entitlement herein before shall be determined in accordance with the order dated 31st March 2010 with effect from 1st April 2010 as confirmed by the apex court. So, my lord, therefore, my lord, in my humble, and this is the stand which has been taken. So, my lord, in my humble submission, my lord, it cannot travel beyond the proceedings of what there is already quietus to the proceedings. Parties have entered into an understanding that it has the imprimatur of the Supreme Court. So, there is already akin to a final decree, which will now, so the relations, the parties cannot, and it is, otherwise also an abuse of process. After filing an affidavit before the Supreme Court, they are filing a fresh writ petition.
Very good.
So, my lord, that is my submission.
Yes, in reply,
Yes.
your application
My
before the
lord.
Supreme Court,
My lord.
page 48 that has been shown.
My lord, my lord. My lord, in the application, nowhere it has been said that the payment was made in terms of the award of the labor court. The 1/30th benefit was accorded in terms of the award of the labor court. Now, my lord will find that.
Then you don't raise this issue before the Supreme Court prior to its disposal.
No, my lord, that interim, if my lord sees the order by which 1/30th was accorded, that was an interim arrangement. My lord may kindly see the writ petition at page number 56, my lord.
Yes.
Kindly see last operative portion of the order at page 57.
Yes.
It says, my lord, some of this also, without prejudice to the right and contention of the administration, this payment is subject to the condition that in case SLP is disposed of. This was a conditional order passed at that point of time when the SLP was pending. My lord, we let them show one document whereby we have relinquished our right so far as the award passed by the labor court. At no point of time we have relinquished our right so far as which has been accrued.
The application, you do not mention that it is being paid from 2010, whereas the direction in the award.
Yes, my lord, from initial date. It is not at the same time, it was not there, they have complied the award.
And 7, page 48, they have specifically said we have complied with.
No, my lord. No, my lord. Admitted fact is that they have not complied. They never said that we have paid you from the date of initial engagement. It is an admitted fact that the payment was made from 2010. Now, my lord will find, even after the order of the Supreme Court, we have made repeated representation before them.
And it was considered and disposed of also.
Never disposed of.
Last page.
Of the
Opposition, it has been read out just now, 54, 55.
It's 54.
Just a minute. My lord.
54, 55, disposed of.
Sorry, considering the finance.
21st of July, 2016.
Subsequent orders. Application of the order was further. In my lord, even in this, they have not stated about the application. So allegedly, they are saying that we have filed before the Supreme Court.
They are relying upon the order passed in the SLP.
They are relying upon the order.
Which was passed relying upon your affidavit.
My lord, there are two occasions why the SLP, because 2015 they have accorded regularization on ad hoc basis. So there were two-fold ground, my lord. 2015, 21st of May 2015. My lord, first order is, if my lord sees in my writ petition, my lord, First order is at page 56, whereby 1/30th was accorded. Thereafter, if my lord sees the page 58, order dated 21st May 2015, whereby regularization was also accorded by them. So there was no live issue at that point of time.
And the date of initial appointment and the date from where payment is being made, this remains disputed according to them.
But at no point of time that was agitated by them. My lord, may kindly appreciate the situation, my lord. They have filed SLP.
I have followed.
My lord.
Please come. Heard submissions made on behalf of both the parties.
Just one, with permission, just one submission. My lord, the issue that is the date from which the payment is to be made, that flows, as my learned senior also submitted, from the 7 June 1988 office memorandum. And they have said at page 48 in their application before the Supreme Court that administration has complied with the notification dated 7 June 1988 and extended the benefits of 1/30. So this they have stated on affidavit after the order of 31st March 2010. And lastly, my lord, if it is not a question of their not agitating their rights, Supreme Court has extinguished their rights by saying that there is no live issue.
List for orders on 10th of December. Yes, call.
Item number 18, rupee number 27 of 2020.
Let me see the file once. Where is the petitioner? Siddharth Singha. He has not come. November. And appears on behalf of the petitioner at the time of call. What to do? Dismiss. What is the issue?
Regarding payment of the arrears.
Yes.
It's a proof vendor. This petitioner is a proof vendor.
Is your opposition on record?
Yes. It is
All completed.
They have filed a reply to my opposition.
List the matter on 9th. Next week I'm keeping it in case he comes.
Item number 19, WPA 2.6 of 2021.
My lord, I am appearing for the petitioner, my lord. Similar matter was disposed of, my lord. I think same order.
Please show me the order.
My lord, I am extremely sorry. I have marked it.
Doesn't matter.
I'm actually.
Is your learned friend aware of the order that you
My lord,
applied?
he opposed me in that matter.
Yes.
मेरे पास भी नहीं है पेपर, क्यों देखता हूँ? ये वो कल्पना गुलतर वाला ना, रुकिए, ये नहीं वो तो बाद में डेट चेंज किया, वो डेट गलत है. सेम था वहां में भी, दोनों का एक साथ ही हुआ था.
Is the petitioner, is the respondent
Same.
okay with the order?
My lord.
Are you all right if this order is passed?
Or it may be posted tomorrow, my lord. Let my learned.
Yes, go through it and come back.
There was a correction in the date. Subsequently, I have corrected it. Another coordinate bench has corrected the date.
All right.
Yes.
Please check up and come back tomorrow.
We'll come back.
To allow the parties to come ready with proper instructions in the matter. List tomorrow.
Item number 20, WPA 297 of 2021.
Ma'am, actually, this matter I have filed in the year 2020-21. Now it is listed, and that time was Corona was there, the COVID period, second wave. So I failed to pay the court fees. Now they asked me to pay the court fees. I am at Delhi now, so it is difficult for me to go to Port Blair to pay the court fee at this moment. So what I want is this: I may be exempted from payment of court fees, and this matter may be heard. And when I return to Port Blair, I'll pay the court fees, ma'am, in the meantime.
Please pay the court fees first and then only your matter will be taken up for consideration.
Okay. Okay. I actually.
Given for payment of court fees? What is the matter about?
So this matter about inquiry may be initiated against the judicial officer. Actually, what happened is that they arrested me in a false case on the basis of a fake complaint by an advocate. And due to what I am having an exam, an UPPCS exam. I have submitted the admit card also, but the judicial officer did not allow my release, and due to which I lost my exam. So I want is that why this on the basis, and that too, they didn't send me. They didn't. I filed an RTI that what FIR they have registered. The police administration have not even give me the copy of the RTI, and they falsely implicated me in a false case just to prevent me from appearing in exam. So what I want is that if judicial officers passes such order under pressure of advocates union, then it will be a disaster for litigants like me, for whom no advocate is willing to appear. No, because I didn't get the benefit of anticipatory bail, even the regular bail was denied to prevent me from appearing in the exam. So that is the reason I filed this petition that inquiry may be conducted. I have.
What do you do now?
Yes.
What do you do right now? Are you in service or studying or something?
No, ma'am, I am not doing. Actually, I got a job in Delhi Metro also. I filed a case before Supreme Court that is pending.
What is your occupation now?
No, ma'am, I am not doing anything, ma'am. At this present, I am unemployed. So that is the reason that may have considered, and that my matter may be allowed if this court finds it fit. Otherwise, I'll because it will get delayed to come to Andaman and to pay fees.
I see the respondents that you have implemented over here is the Union Territory Administration through the learned public prosecutor. It is not done.
Yes.
And the Registrar General, Calcutta High Court.
Yes, I have made the party registrar.
Here, why will you implead the Registrar General of the Calcutta High Court?
Because I want that Registrar General should initiate the inquiry that why the judicial officers are under pressure of the Advocates Union, they are passing such order to prevent me from appearing in the exam, because I have requested them repeatedly in the bail application also, but they denied my bail. So I lost my exam, ma'am, because the court can't prevent somebody from appearing in the exam.
Who asked you to prepare this writ petition?
I filed my own. I have drafted my own, because no advocate is willing, because this is
Your petition appears to be a defective one.
Okay, you can, ma'am, because I have no other option. I have drafted my own. You can dismiss. I'll move Supreme Court, ma'am. No issue. You can dismiss the petition.
That is something else. There is
Yes.
you can always move Supreme Court and the International Court of Justice also. That is something else. Thing is, your application is required to be in proper form. Where are the parties? In the writ petition, the parties are not, the nomenclature is never opposite parties. The union territory is represented by somebody else and never through the learned public prosecutor. The cause of action, if it is arose in the principal bench, it should have been filed there. If it is here, then the registrar over here ought to have been made a party.
No, I am not from any legal background, and no advocate is willing to appear.
This is the
So in
difficult.
that case,
You do not have
yes,
the, you do not know how to prepare writ petitions and you have filed the writ petition. It's an absolute defective one.
no issue, ma'am. The court can dismiss on that this is on the basis that it is defective one. This court can dismiss. No issue.
If you make the submission that the court will dismiss, then the court will certainly dismiss. But prior to
No issue.
you have to pay the court fees.
Okay, sure, I'll pay the court fees.
When will you
But
pay?
I need time. I'm at Delhi now. I'll send someone because I told my friends they are not getting time, so they told that they will pay. I have to send someone to the court registry to pay the court fees.
It's nearly a month when direction was filed. Direction was given.
Yes.
The petitioner is yet to deposit the court fees. Stop. On the prayer of the petitioner appearing in person in the virtual mode. Time to file the court fees is extended. How soon can you file it?
Ma'am, I told somebody because I am at Delhi now, I don't have anyone known about Blair. I am from Diglipur, North and Middle Andaman. So I
date. Otherwise, your writ petition will be dismissed.
Ma'am, 15 days time may be given, 15 days.
12th of November, you were given time.
Sure. Yes.
We are 3rd of December. When will you file the court fees?
Yes, within 10 days, 10 to 15 days, I'll pay the court fees.
How many days?
15 days.
15 days.
Yes.
What did I say? On the virtual vote, seeking a fortnight's time to file the court fees, to deposit the court fee. The matter stands adjourned till the next circuit. Stuff. The court fees shall positively be paid within a fortnight from date. Paragraph B, it recorded that wide order dated 5th November 2024. Time was granted to the petitioner till 12th November 2024 for filing the court fees, which has not been filed. Stop. Time to file the court fees is extended as per the request made by the petitioner. Stop. Paragraph. It is made clear that in the event court fees is not paid within the time specified herein above, the writ petition shall stand automatically dismissed.
Ma'am, I may be allowed to pay online if possible, madam, because online procedure also there to payment of court fee in Calcutta High Court. I may be allowed to pay.
Call madam, please.
Item number 21, WPA 133 of 2022.
My lord, I am appearing for the petition, my lord. I can
Yes.
start it or I will do it tomorrow.
It is up to you. No piecemeal argument. Today you will start there.
Tomorrow.
Tomorrow. Very well. On the prayer of the learned advocate appearing for the petitioner, hearing of this matter stands adjourned till tomorrow.
Item number 22, WPA 177 of 2022.
Passed an order directing DC to produce certain. I know you can see the direction part.
Yes. Deputy Commissioner, South Andaman District was directed to cause inquiry and file a report. Where is it? Who is there? Arun S. Kumar. Rakesh Pal Govind.
My senior Mr. Govind appears for the private respondent.
Yes.
Not with Mr. Rakesh Kumar was appeared on the last occasion.
On behalf of Mr. Rakesh Kumar. Yes. Where is he?
He's in the other court.
He's in the other court. Passover. Where is the report? The court wants the report. Accommodation has been sought for on behalf of the learned advocate representing the respondent numbers 1 and 2. List the matter tomorrow.
Well, 23 and 24 just not today.
On the prayer made on behalf of, made by the learned advocate for the petitioner, list the matter tomorrow. Next matter. Record your appearance, please.
Item number 25, WPA 240 of 2022.
We are appearing for the respondent authorities, my lord.
Yes. Let me see the files. What is the IA for? Can is for?
No, dispense.
Has it been disposed of? No, the can is there. Has the relief sought for in the application been allowed?
No.
Are you pressing? Who is pressing? Whose application? Your application? No, I get it, but whose application? Backsheet ta dekhun to ka.
No, I am not.
Yes, it's your application.
No. We are. Maybe fix.
26th of February 24, the Honorable directed personal appearance of the secretary. There was a personal direction for personal appearance.
That was discussed with my lord.
When? 22nd February. 22nd February.
The order dated 28 February 2024.
20.
For filing affidavit in opposition. Thereafter affidavit in opposition has been filed.
Personal
Concerned officer appeared.
Yes. Can 1 is accordingly disposed of.
It can be disposed.
Record an order in can 1. In view, no, the application was filed for recalling the order dated 26th February 2024. Stop. It appears that with the order dated 28th of February 2024, the prayer sought for by the petitioner in the application has been allowed. Stop. In view of the above, can 1 of 2024 stands disposed of. What about the main matter?
Hearing, we have filed opposition.
For Monday, this matter for meanwhile we will file our reply. Monday, this matter.
On the prayer made on behalf or made by the learned advocate representing the petitioner, time to file the affidavit in reply is extended till 9th December 2024. List on 11th December 2024, marked for hearing.
Much obliged.
So it's over.